Good morning, everyone. This is day 5 of the Theodore Edgecomb trial. We had day 1 jury selection. So, today, let's see what happens. Judge is not very happy. He wants to get this show on the road. No more screwing around. So, if you guys have any questions, feel free to put them in the chat and we can talk about them. It's very nice by the defense. Oh, they're going to call some officers. That could be interesting. That said, though, it was very, I think that's very fair. The judge let the paralegal back in. I understand he was probably getting a little pissed off at the end of the week, so he kind of said, fuck it, but it makes sense she's allowed back in. I don't think she did anything wrong. The attorney she worked for may be an idiot, but she didn't do anything wrong. And there's Theodore sitting in the back. Nice, actually, a very nice blue suit. Nice tie. Very nice tie. I'd wear that tie. I don't think I'd wear that shirt, though. Judge getting his phone charger set up. Oh. Oh, come on, Streamlabs, you're killing me here. Hate it when it does this. I'm sorry. Oh, yeah, thank God I got the bagels. Funny guy, Sully. So let's see where this goes. I don't, yeah, non-Browns problems. I don't care. Yeah, really, I don't care. I don't care. This is working man trying to get his shit done. Has to come to court instead of work. That's great. Come on. This is frustrating. Hi, everybody watching. Any questions? You can put them down below. We can talk. It's a landlord. Sorry about that, guys. Had a little bit of difficulty with the Streamlabs, but it's back up and running now. Laugh all you want, Judge. That guy's got a roll, man. Time is money. He's cutting the amount of driveways he can plow. So he's going to show why the bicycle's not normally stored down there, as to prove Theodore was fleeing. Kind of wondering where they were going to go with this. Well, actually, he's holding up an envelope, so I wonder what that's going to be. Did they find the... Well, they didn't find the gun. They said they haven't found the gun, so... The fuck did they find? Because they found the ammunition and magazines upstairs. And all the gun stuff in his room, so... I'm a little curious now. Oh. Okay, so it was the bike. That makes sense. Mm-hmm. So yeah, this is just to show that the bike is never in the basement, and this goes to show his evidence of flight and the evidence of guilt, trying to hide evidence. Wait, if he stored it in the house all the time, why not just keep it in the house? What a fucking idiot. Theodore, not this guy. Sorry, I had to blow my nose. Didn't think you guys wanted to hear that. At least he's admitting it was a bad question. A lot of times the trains will plow through. Hey guys, well, I say new people viewed. Welcome to Theodore Edgecomb trial. The state's wrapping up. This is the landlord for Theodore's house, showing that proof the bike was stashed in the basement. I don't know why they wouldn't just stipulate to his knowledge of Theodore Edgecomb. Ooh. Introducing the new photo showing he changed his appearance. That's a subtle way of getting that in. So when he was arrested, he looked a lot different than he looks now. I'm sure it's going to be a barn. Wow! They actually did it right for once. Cut this guy loose. There's nothing to gain. Good job. Bravo, gentlemen. Bravo. Hmm. Hmm. So he interviewed her. Huh. Excuse me. I think that was a good objection. You got to make it, but it will be overruled. Outrun on the court reporter. I've had that happen before. I don't. I don't see the point in showing some of these inconsistent answers here. Whether or not he said "what the heck," "what the fuck," I think we all know what was said, and I think it's clear she's not reliable, but it doesn't change the ultimate facts of what happened here. Sorry, the meter guy's out there driving my dogs crazy, so I apologize. Let it go. You're not going to get anything good out of this guy. Don't do it. Do not do it. Really mean it. All right, let's see what Battery's going to fuck up this time. If last week's any indicator, he's going to fuck this up and, I don't know, maybe hurt his client even more. Yeah, sorry, you guys. I'm still messing with the Streamlabs stuff. I touched something that goes bad. Sorry. Oh, we're going back to the whether or not. Oh, I know who this guy is. He's the one they tried to pin it on with Clabundi, that they didn't look for everything. This is part of that conspiracy that, oh, they didn't find anything. They didn't look. Because there's no camera of it. We don't know. Irrelevant. That's not true at all. Yeah, he said he told her. Oh, great, she broke the traffic laws. The horror of it all. Too late. What? What the fuck? They must have witnesses that can testify to the tire screech. Also, somebody seeing Jason bail out of the car. Wow, 17 viewers. Hey guys, it's Theodore Edgecomb's trial. If you have questions, throw them in the comments. Throw them in the chat. We can talk. Yes. Yes. Ooh. Ooh. Oh. Ha ha. Oh shit! That was bad. You get thumped on in front of the jury. That's bad luck. That's a bad luck. It's never good. Yes, because you've already done this a million times so far. Hmm. It's actually. Mhm. Wow. This judge is at his wit's end. Ha! Yeah, after that tongue lashing, I wouldn't remember it myself. I've kind of forgotten it. This is the safe bet. Have the reporter Sans read it back. It's a safe bet. Um, yeah, the judge is kind of pissed. They've watched the video a million times. It's not going to change anything. Uh, and also, what the judge kind of got mad at earlier, that's Theodore's good. It's going to be Theodore's testimony that he felt scared, he was in fear of his life. That hasn't been introduced yet, so there is no evidence to base that on. So they're facts that aren't in evidence, so they can't bring it up. Why can't we? Oh, apparently some of you guys can't hear. I am sorry. Let me work on that. Let me know if that's better. I'm trying to figure out what to do with the sound. Hmm. Hmm. Let me know if that's better, guys. It's a fairy. Hmm. Can't hear me, but not them. Hmm. Well, let me work on that a bit more.
My name is Emily Schmidt.
Student, speak up. Use your outdoor voice.
My name is Emily Schmidt. EMILYSCH.
Student, speak up. Use your outdoor voice.
My name is Emily Schmidt. EMILYSCH.
Student, speak up. Use your outdoor voice.
My name is Emily Schmidt. EMILYSCH.
Student, speak up. Use your outdoor voice.
My name is Emily Schmidt. EMILYSCH.
Student, speak up. Use your outdoor voice. Student, speak up.
As a DNA analyst, as to DNA and DNA identification in the state of Wisconsin before?
Yes, I have.
How many times?
Over 25.
Okay. And this may be impossible for you to know, but approximately how many
Around 100 cases a year. Each of those cases may contain anywhere from 3 to 10 plus items of evidence, so several thousand pieces of evidence.
Now, let's start off. What is DNA?
So DNA is sometimes referred to as the building block of life or the genetic blueprint. This is because it makes up all living things, including us as human beings. So we inherit half of our DNA from our mother, half from our father. Our DNA is the same from our life until our death. It's found in all the nucleated, all the nucleated cells in our body. And it's unique to us as an individual, with the exception of identical siblings who share the same DNA profile.
Okay. And when you are, when we're talking about DNA, if I touch an item or hold an item, does that mean that my DNA is going to be on that item?
So when you touch an item, you're likely transferring skin cells, which contain DNA, to that item. Whether or not we can detect the amount of DNA that was transferred is another matter, but most likely, yes, you are transferring DNA.
Okay. And when someone is, let's say, have touched or handled an item, does that mean you're always going to be able to pick that up with a swab?
No, it does not.
Why not?
So the amount of DNA that we would need to get a profile is very small, but it depends on the type of transfer. So if you touch it really fast, you may DNA behind to collect.
So guys, today's Theodore Edgecomb. Sorry I had to mess with the audio and fight with it. Right now is up as the DNA tech, and she's going to talk about, well, we'll just tune in and listen and see what she's going to talk about.
Meaning that it would kind of break down and we might not be able to detect a profile.
And then you mentioned potentially like wiping stuff off or rubbing things, or you could get rubbed off. That could affect your ability to get DNA off an item.
Let me know if you guys are having any issues hearing me or her.
The actual item of evidence.
Yes, occasionally.
And when you get an actual item of evidence and they want to see if you can identify if there's DNA on it, how do you do that? How do you process that?
So if we're talking about an item of evidence like a piece of clothing, we would look at that item of evidence, and depending on the case circumstances, we may be looking for a body fluid such as blood, semen, or saliva, which would do a visual examination for those items or those fluids. If we're just looking for something like who wore a shirt or a sweatshirt, we would examine the item and take a cotton swab that looks kind of like a Q-tip with just a swab head on one end, and swab the area that we're looking to collect DNA from. And then that swabbing would be processed for DNA.
Are there times where you just receive swabs?
Yes.
And those are swabs where, let's say, a police department swabs certain items of evidence and they go to you. Is that correct?
That's correct.
Okay. Now, when you either yourself, like trying to figure out if someone has touched a firearm or looking at a swab that police believe someone may have touched or handled, when you receive these swabs, are there times when you have received swabs that people believe that there might be DNA on it, and you just find no human DNA on it?
Yes, that does happen.
Okay. Are there times when you get swabs and there's human DNA, but there's not enough for testing purposes?
Yes, that happens too.
Can you explain what that means?
So our laboratory has some validated thresholds that there needs to be a certain quantity of DNA to process the sample further. If the quantity of DNA in a sample is above that threshold, we know we'll likely get a DNA profile. If it's below that threshold, based on our validation and studies, we won't get a DNA profile that's usable, so they won't be processed further. So we'll say that there's not enough DNA present.
Are there times when you can get a profile? Actually, before I get that, are you familiar with the term STR?
Yes.
What is STR?
STR stands for short tandem repeat. Develop a DNA profile. So you can kind of think of it like if the DNA strand is one sentence, the STR is one word within that sentence. So we're looking at these words or STRs on the DNA and counting how many times they're repeated in a row over and over again. And that repeat number makes up part of your DNA profile.
And so that is how, when you're looking at STR, you get the STR profile for potentially an individual.
Yes.
And you're looking to compare that profile from an individual to what you may see on a piece of evidence.
Correct.
Are there times when you can get DNA from more than one person, either on a piece of evidence or a swab?
Yes.
That is called a mixture.
That is called a mixture, yes.
Okay. Now, we're going to talk a little bit about, because there are mixtures in this case, are there not?
Check out my big science brain,
Are
everybody.
there times when you can have a mixture?
Hey guys,
but
if somebody
it's
could comment,
just too low level.
I know you guys can hear me. Just want to check you can
Yes.
hear the actual trial as well.
So sometimes when we look at a mixture of DNA, that's DNA contained from more than one individual, maybe there wasn't a lot of DNA there to begin with, and the profile is just very limited or partial, and it doesn't meet our standards for being able to make any comparisons to.
Okay. Now, are there times where that mixture of more than one person can be too complex for you to do anything with?
Yes.
What does that mean?
So in that case, similarly, we're looking at a mixture of more than one individual. In cases where it's too complex, that may mean either there's too many individuals to determine how many.
Thank you very much,
contributed DNA
Timbits.
to that profile. It may mean that the components of the mixture are too kind of intertwined, mixed up. We can't determine if there's, which profile came from which individual. We can't really separate it out, and it's too complex to make any comparisons to at that point.
Are there going to be times?
That's a
when
very
you have
common,
mixture
actually. It
that
happens
you
a
are
lot.
able
You
to
can't
identify
differentiate.
what's referred to as a major contributor?
Yes.
What is a major contributor?
So a major contributor to a mixture profile would mean that individual that is contributing more DNA than any other contributors in the mixture. So when we're looking at the profile, which when we visualize a profile, it looks like peaks on a graph. So those peaks would be higher, and there would be like minor contributors lower, and we can identify that, like, okay, all of these ones that are higher up are distinguishable and different from the lower contributors, so we can kind of pull out a portion of that mixture.
Thank you,
And
Leanne.
can you sometimes make, I guess, what's referred to as a source statement or identify who the major contributor is?
Yes.
Okay. Are there times where you can't make a source statement?
Yes. So when we're looking at a mixture profile and there isn't one distinguishable component like a major, we can't say someone's definitely the source of that because it's coming from more than one individual. So the only time we can say it's source is if it's a profile coming from one person, or if the major coming from one person was pulled out of a mixture.
Okay. Are you sometimes, when you're figuring out who the major contributor is, can you sometimes figure out who may also have contributed DNA into the rest of that mixture?
Sometimes, depending on what the profile looks like, we can also make comparisons to the minor portion, but not always.
Okay. And this is kind of going to be the last portion that I want to talk about here. When you, as a crime lab analyst in the field of DNA, are making a source statement saying this person's DNA is on this piece of evidence, is there a statistic or a probability ratio that has to be met under your standards?
Yes. So for our lab to be able to say that someone is the source, the statistic associated with that is over 1 in 7 trillion, which is approximately 1,000 times the world's population.
Okay, so unless it meets this ratio of basically 1 in 1,000 times the Earth's population, you can't say it's someone's DNA, can you?
Correct.
Everything other than that is what, just a consistent with?
Consistent with, and we would state a statistic, yes.
Okay. Now, additionally, are you familiar with the term buccal swab?
Yes.
It's pronounced buckle. I usually say buccal, but is it buccal?
I say buccal.
All right, great. What is it?
Buccal.
A buccal swab is
What
a
a
swab from the inside of
tool.
someone's cheek. Those are the buccal cells on the inside of your cheek.
The buccal swabs are the big
It
Q-tip looking things
is a
you
known
see on TV.
standard coming from that individual. So that's what we would use to say that's my DNA profile, and I can compare it to the evidence, for example.
And when you're dealing with live individuals, that's usually a buccal swab. Is that correct?
Correct.
When you receive DNA standards from an autopsy, how do you normally receive that?
Those are received as a dried blood standard.
Okay.
A dried blood standard.
I want to show you what has been marked as State's Exhibit number 91. I'd ask you to take a look at it and tell me if you recognize it.
Exhibit number 91 is a copy of my confidential report of laboratory findings for laboratory case number R202996. Laboratory case number R202996.
Now, just so we just talked about that, you just mentioned, which we sometimes refer to as the R number, right?
Yes.
And so when any piece of evidence associated with this case goes into the crime lab, whether or not it's
At this
you
point,
or
I
another
think he's
section, it gets
toast,
the same
but
R number.
Correct.
Okay.
there's still time left
Now-
on the clock. Anything is possible.
And this is the first
What they're
run of
doing
evidence,
here is
that
showing
correct?
we did actually try to find
So,
DNA, but we
for
couldn't find any
example,
DNA.
We can see it's items C through J.
This prevents the defense from saying, why wasn't there DNA
Juice
evidence?
bottle, swabs from prescription glasses, a dry blood standard from Jason Clearman, and then a number of swabs and clippings from his body. Is that correct?
Correct.
And what are the last two swabs that you received?
The last two swabs received in this submission of evidence to the DNA unit were item I, swabs from the left bicycle handle and brake, and item J, swabs from the right bicycle handle and brake.
Okay. Now, let's start off with the juice bottle. Were you able to identify any human DNA on that bottle? Item C.
There was DNA present on item C, yes.
Okay. And when we are talking about this, was it a single person or was it a mixture?
So the profile from the juice bottle was a single low-level profile, so one single person.
And was it sufficient for testing?
Yes.
Okay. Now, did you run it by Mr. Clearman's DNA?
Yes.
And did you come to any conclusions?
Mr. Clearman was excluded from this profile.
Okay, so he didn't, as far as you can tell, you can't place him anywhere near that bottle.
Yeah, he didn't contribute to the DNA profile that was collected from it.
Okay. I now want to show you what's been marked as State's Exhibit number 98. I ask you to take a look at this. Tell me if you recognize it.
Exhibit number 98 is my supplemental report of laboratory findings from the same case, R202996.
This is several months later, is that correct?
Yes, it was.
And this supplemental report kind of goes through a lot of the items we're about to talk about, but the additional testing with a new standard you had, is that correct?
That's correct.
What was the new standard you received?
So there was an item L, standard from Theodore Edgecomb.
Okay. Did you run Mr. Edgecomb's DNA against that bottle?
Yes.
And did you come to any conclusions?
Mr. Edgecomb was also excluded from this DNA profile.
So for all we know, it's just a random bottle.
Correct.
Okay. Now, I believe the next item, item D, is prescription glasses. Is that correct?
That's correct.
Okay. Did you find any human DNA on the swabs from these glasses?
Yes.
Was it a single person or was it a mixture?
The DNA from the glasses was a mixture of 2 individuals.
2 individuals on the glasses?
Yes.
Okay. Were you able to come up with a major contributor?
Yes.
And what conclusions did you come as to that person's identity?
The major contributor from the glasses swabs, I identified Mr. Clearman as the source of that major profile.
So he's on his glasses.
Yes.
Were you able to come
That makes
to any
total
conclusions
sense.
as to the identity of that second person?
No, I was not.
Why not?
So the minor portion of this profile there was just not enough DNA there, so it was too limited to do any comparisons to.
That's
If
not at
somebody
all
had
uncommon.
punched and hit these glasses and DNA goes on, you can't tell us who that person was just from what you have right there.
Correct.
Okay. Now, were there fingernail clippings from Mr. Clearman?
Yes, there were.
And did you find any human DNA on those fingernail clippings?
Yes.
Did you come to any conclusions as to those?
So all 4 sets of fingernail clippings that I processed were a single source male profile.
Only him.
Correct. Mr. Clearman was the source of those profiles.
Okay, so just from that, you can't tell whether or not he had a physical interaction with anyone else with his.
Yes, that's their way to show he didn't get into a boxing match, but
Additionally,
it doesn't mean he didn't.
Were there swabs from other portions?
More than likely, he did not punch Theodore.
There were also swabs from Mr. Clearman's hands as well as his face.
Okay. Did you run DNA testing on all of these swabs?
Yes.
And what, if any, conclusions did you make on any of these swabs?
So from the hands swabs as well as the face swabs, those were all single source male profiles as well, and Mr. Clearman was the source of those profiles.
What about on the right side of his face? Did you find any DNA? Was it only Mr. Clearman?
Yes, that was also a single source profile. Then Mr. Clearman was the source.
So if somebody punched him on the right side of the face, DNA can't tell us anything about it.
Correct.
Okay. Now, the last 2 items of DNA evidence.
Sorry about that. Another oopsie.
Are items, I believe, I and J?
The bicycle swabs, yes.
Okay. And where were these purportedly taken from?
So item I was reportedly taken from the left handle and brake, and item J from the right handle and brake of the bicycle.
I'm placing State's Exhibit number 60 on the big screen. I want to just be clear, are you present when any of this stuff is taken?
No, in this case, I just received swabs.
Okay. So you don't even know if State's Exhibit number 60 is where these swabs were taken from, do you?
No, I don't.
Do you know how all of these swabs play out into the larger investigation?
No.
All you know is the stuff comes in.
This right now is how they can establish
Correct.
they have Theodore's DNA to
Now,
compare against.
Did you find human DNA on both swabs from both the right and left handles and brakes?
There was human DNA detected on both the right and the left handle. The right handle and brake swabs, there was only a limited amount of human DNA.
So the right, if we're looking at it, what did you say about the right?
There was human DNA was present, but in a limited amount, so it didn't meet that quantity threshold to develop a profile.
Well, he didn't find enough
What
DNA
did
on his own
Can you
bike.
tell us if it was one person, multiple people?
I can't because it wasn't processed past that quantity stage.
So there was so little human DNA on this brake and handle that you can't tell us who may have been holding on to this brake and handle of this bike.
That's correct.
Okay. What about the left?
On the left bicycle handle, I was able to develop a DNA profile that was a mixture of 2 individuals, including at least 1 male.
Why do you say at least one male?
So male DNA is, so we have an X and a Y chromosome. Only males have a Y chromosome.
Being
that
very
location.
gender normative,
We
lady.
can see that there's a Y present. We can't see if there's more than one present to determine if there's more than one male. So we say at least one.
Okay, so you see two people's DNA, or DNA from approximately two people. At least one of them is male. Could be both. Could be just one. Right?
That's right.
Okay, so there's limitations. In terms of this mixture, were you able to come to a major contributor?
No.
Why not?
So the profile, there wasn't a clear individual that was the major in this case. It was processed assuming seeing who was included into the mixture in general, looking at both parts of the mixture.
Okay, so you're saying what we're about to talk about is just talking about that this person is part of the mixture. Maybe major, maybe minor, you don't know.
Yes.
Okay. Jason Clearman, was his DNA in part of this mixture?
So when we compared Jason Clearman's standard to this mixture, it was determined that it was at least 917 million times more likely to observe the DNA profile if he was not included in the mixture than if he was included in the mixture, which is a lot of talk to say that there's very strong support that he's excluded from this mixture profile.
Most likely he's not on that.
917 million, more than...
Correct.
But just to be very clear, you're not testifying he's not on there, are you?
Correct. I'm saying there's strong support that he is not.
Okay. Now, what about Theodore Edgecomb?
When we compared Mr. Edgecomb's DNA to this profile, it was determined that it was at least 1 quadrillion times more likely to observe that DNA profile if Mr. Edgecomb was included than if he was not included. This is equivalent to saying there's very strong support for inclusion of Mr. Edgecomb in the mixture profile.
So it is most likely that Mr. Edgecomb's DNA is on the
1
left
quadrillion.
and the
Yeah,
left.
that's...
Yes, there's strong support.
There aren't that
he's
many
included
people-
in that mixture profile.
Maybe, you have to go hunt down creatures to get to that
I
level.
cannot say that he's the source. No.
Can you even tell us whether or not he's the major or the minor contributor?
No.
Additionally, when we're talking about this DNA, can you tell us how long any of this DNA was on any of these items?
No, I can't.
Can you tell us, is it possibly well, this looks like it may have been put on within the last hour or two?
No.
There's not like a DNA clock where you can kind of figure out based on degrade, like we see in CSI, that it's somehow more recent DNA?
No.
Why not?
So DNA can be present on an item for a long time. We may be able to tell that if it's very degraded, it might have been there a long time ago, but not necessarily, because it can also be degraded by being wiped away, being out in the sunlight, etc., or exposed to high heat. But no, I can't say that when it was placed there, just that there is DNA on.
You
the
can't
item.
establish DNA like it's
Just
time
so
of
we're
death.
clear, this DNA that has been found, for example, on these bicycle or on the bicycle handles, you don't know how long they were.
No.
You can't tell us whether or not they're put there on the day that the police found them, a week before, a month before, whatever. Is that correct?
No, I can't say.
Okay. Your Honor, the state would move states exhibits numbers 91 and 98 into evidence.
Any objection?
No.
Received.
No further questions. Thank you.
Cross.
I don't know why they're going to cross her. There's not a whole lot. I don't know why. They're not really going to gain a lot out of this if they want to go after
Good
her.
morning.
Fair to say, if
Let's watch.
an item wasn't submitted for testing, you wouldn't have a DNA result, right?
Correct. If there's nothing for me to test, I have no DNA results from it.
Okay, and just to confirm in this case, case number R20-2996, you never received any item for testing such as a knife, correct?
No, I did not.
You also didn't receive an item such as a White Claw can, correct?
No.
As far as the
I bet the White Claw can would have
standards
had
we were
Jerry's
talking about, and I
Jason's
think you
DNA on it
referred
because
to
it's in his car.
a buccal swab, right?
Correct.
So for Mr. Clearman, was that also a buccal swab standard or some other kind of swab?
So for Mr. Clearman, it was the dried blood standard that I said we typically get from if it was submitted at autopsy or from an autopsy.
And that was item E in your report, right?
Yes.
Okay. So you received that, and then you ran some testing against that standard to see what that matched up with in terms of the items, correct?
So I ran the evidence profiles, and then after looking at those, made the comparison from the standard to the evidence.
Okay. And then at a later point in time, you also received Mr. Edgecomb's buccal swab, right?
Correct.
But you never received Evangelina's DNA profile, correct?
No, I did not.
And when I say that, I mean Evangelina Clearman. You never received any sort of standard from her, right?
Correct. I did not.
So none of the evidence was compared against her profile. Fair to
Objection
say?
on irrelevance.
Sustained.
I have nothing further.
You also never got swabs from a murder weapon, did you?
I don't think so.
Any swabs from a 9mm handgun?
No.
Nothing else, thanks.
Defense, anything?
Let it go.
All right, you can step down, ma'am. Thank you. Does the state have another witness?
We do. State calls Heather Williams.
When you guys are seeing the prosecutor throw those files into that box, he generally has a file per witness. All the questions he's going to ask, all the evidence that they're going to go over. So that's part of the planning. I think this is another detective. Probably going to talk about more evidence collection. I'm not really sure, though.
I do. Please be seated. State your full name, spelling first and last for the record, and you may remove your mask.
First name is Heather, Heather. Last name is Williams, Williams.
You can move the microphone over a little bit. Thank you. How are you employed?
I am a firearms and tool mark examiner at the Wisconsin State Crime Laboratory located here in Milwaukee.
And how long have you been a firearm and tool mark examiner?
Approximately 6 years.
Such a Wisconsin
In order to hold your
accent.
position, do you have to have any specialized training or experience?
Yes.
Could you briefly tell us about that?
I first hold a Bachelor's of Science degree in Law Enforcement and Justice Administration with a minor in Forensic Science from Western Illinois University. I also completed an internship at a forensic crime laboratory, and I also completed the Wisconsin State Crime Laboratory Firearms and Tool Mark Training Program. It's an apprentice-type training program, much like, say, a plumber or electrician, in which you get both hands-on and classroom-like instruction.
At the conclusion of that training, is there some testing or something that you have to go through in order to become a firearm and tool mark examiner at the crime lab?
Yes, we are required to complete competency tests, which is mock casework. Once that has been successfully completed, we are then authorized to perform duties in the firearms and tool mark discipline.
And then is there further testing that occurs as you remain in employment in this position?
Yes, we are required to complete and pass proficiency tests in the different areas of firearms and tool mark examination on a yearly basis.
Have you testified as an expert before in the field of firearm and tool mark examination?
Yes, I have.
Approximately how many times?
If I recall correctly, this will be my 49th opportunity to testify.
And in terms of handling or looking
It's
at
a lot of
items
testimony.
evidence, is it even possible for you to tell us how many items of evidence you've looked at?
At this point, I believe I've done approximately 24,000 examinations on over 8,000 pieces of evidence.
Okay. Now, to begin with, what is firearm and tool mark examination?
Firearm and tool mark examination is the comparison analysis of fired evidence compares bullets to barrels and cartridge cases to firearms.
And when you are doing that, comparing bullets to firearm barrels and cartridge casings to firearms, what are you looking for?
We're looking for the markings that are left on the firearm that the fired cartridge cases and fired bullets have. These are caused by different parts in a specific firearm.
Now, are you able to use those markings that you see in an attempt to compare cartridge casings to other cartridge casings?
Yes.
And can you compare bullets to other bullets?
Yes.
Okay. Now, I want to start off by showing you what has been marked as State's Exhibit number 32. I'd ask you to take a look at it for me and tell me if you recognize it.
I recognize this as one of the items that I analyzed for this specific case. I know that based upon the yellow laboratory sticker, has the laboratory case number associated with this specific case, the item designation for this specific case, as well as it has my initials and date that I took this piece of evidence into custody. Also, the packaging is going to have my initials and date that I completed my analysis on the evidence. And the actual physical cartridge case here is going to have the laboratory case number, item designation, my initials, and the date that I examined this piece of evidence.
And you state you actually, literally carved that into the item of evidence. Is that correct?
Correct, yes. We scribed that information into the piece
This
of
is what you've heard of before as chain of custody evidence.
Just so we can make certain that you can see on there. Is that correct?
Correct, yes.
And that's just what? The laboratory case number and things like that?
Yes, it'll include the laboratory case number associated with that piece of evidence, the laboratory designation, so the item letter associated with that piece of evidence, my initials, and then the date that I completed my analysis on that piece of evidence.
Now, what is the caliber of this firearm again?
That cartridge case is a 9mm Luger caliber cartridge case.
Okay. I'm going to show you what has been marked.
9mm Luger is just general 9mm.
Take a look at that for me and tell me if you recognize it.
I recognize this as a fired bullet that I analyzed for this specific case. Once again, I know based upon that laboratory sticker, as well as all of the case information on the packaging, as well as on the actual piece of evidence.
Were you able to come to any conclusions as to that bullet?
I was able to determine that that bullet was a 9mm caliber full metal jacket bullet, and that it had 6 lands and grooves, or markings that are left by the rifling or that spiral pattern within the barrel of a firearm. And it also had polygonal type rifling.
Okay, and when you're referring to lands and grooves, that's what kind of grabs the bullet and spins it, is that correct?
Correct, yes, that's that rifling. So once again, that spiral pattern that if you're looking to the barrel or the inside of the barrel, you'll see a spiral pattern, and those are called lands and grooves.
And that's, just for an example, when a quarterback throws a perfect spiral, it kind of gets what gives it its accuracy and allows it to go in flight. Is that correct?
Correct, yes. It helps with that stabilization of the bullet.
Okay. Now, in terms of that fired bullet, what is the caliber of that fired bullet?
That fired bullet is 9mm caliber.
Now, are you able to tell us whether or not this bullet and this cartridge casing came from each other?
I am not, no.
Why not?
Because the markings that are left on a fired bullet and a fired cartridge case are going to be from different areas of a firearm. The fired bullet is going to be caused by that rifling that's within the barrel of a firearm, or the markings that are left on there. And with a fired cartridge case, there's going to be different markings that are left on different parts of the firearm, which would include a firing pin impression, an ejector mark, extractor mark, breech face marks, and even chamber marks, to name a few.
So as it stands right now, based on your experience, you cannot tell us that this bullet was fired from this cartridge case?
She can't.
I cannot, no.
She's missing the critical
You
part.
had the firearm, the murder weapon.
If I had a firearm,
Exactly.
I would be able to compare test-fired bullets in cartridge cases that
They're
I would
pointing out he
produce
ditched
from
the
that
weapon.
firearm to then compare to the evidence on this specific case to be able to determine if the fired evidence bullet and fired evidence cartridge case was or was not fired in that submitted firearm.
So you could, if you had a weapon, state that weapon fired this bullet. Is that correct?
If I had a weapon, I could do that comparison, yes.
And then you could also compare the cartridge casing to that same weapon, and while not connect to each other, you could connect them to the same firearm.
Correct, yes.
Did you ever receive a firearm in this case?
In this case, I did not.
So without the firearm, without wherever that thing is, you can't tell us if these two things are connected.
Correct.
Is everything you've just testified to, let me just show you one exhibit. I'm going to show you what's been marked as State's Exhibit number 99. Do you recognize that?
Yes, this exhibit is the report that I authored for this specific case. I know that based on the laboratory case number associated with this case, as well as it has my name and signature showing that I was the analyst that authorized this report.
Is this report contain everything we just testified about?
Yes.
Now, there is one other thing or one other portion of this in regards to the cartridge casing and the fired bullet I want to talk about. They're both 9mm. Did you determine that they had any characteristics or anything similar to a possible particular brand of firearm?
Yes, based upon the class or basic characteristics that I saw on the fired bullet and fired cartridge case, I was able to
Ruger
determine
American
that it's
or SR9.
possible that the fired bullet and fired cartridge case were fired from a 9mm caliber semi-automatic pistol manufactured by Glock.
Glock, but we found a Glock, but we found Ruger magazines in the basement. Interesting.
Nothing else, thank you.
Garage.
One moment, Judge. We have no questions, thank you.
All right, you can step down, ma'am. Thank you.
State rest, Your Honor.
Stay rested.
Oh,
please.
we're done.
Rebuttal.
Yes.
All right, I'm sending the jury out. What that means is the state is resting their case subject to rebuttal. I'm going to send you out for maybe 15 minutes, 20-minute break.
Partway done,
Back,
sports
I'll advise
fans.
you on how we're proceeding. Follow my bailiff out. I'm sure you remember all the rules from last week. No discussion of the case, no deliberating. We'll see you back in about 15 minutes. I'll let you know how we're proceeding and progressing for the rest of the day.
I agree,
Everybody
Demetrius,
else can
but
remain seated,
his
please.
attorneys are paid for, and these guys hold themselves out to be pretty good. They aren't public defenders, so I just think he picked a couple of crappy attorneys who got in over their head. Once again, the prosecution just hammered away
So
on
we'll take a
throwing away the
15-minute
gun.
recess. I presume the defense is presenting a case. Is that correct?
Yes, Your Honor. Couple of things, though, I want to place on the record. I believe during the redirect of Detective Alvarado, the state basically commented that the defendant didn't make a statement or come to the police. I think that's improper because we didn't open the door about that. We talked about a different, I don't remember exactly what was stated, but to contrast what the defense had asked during cross.
That's not
Huber's,
Fifth Amendment related, I don't
redirect
think.
Mentioned the defendant didn't come to a police station, didn't come in or whatever. So I think that's a right to silence sort of violation there.
Mr. Huber.
Your Honor, commenting on the defendant's right to silence would be if I was talking about the fact,
Yeah,
or
it's-
commenting on the fact that when the defendant talked to police, he remained silent. This is talking about the fact that she remained on the scene and provided them information, and they're stating, well, why didn't you do this? The defendant didn't stay on the scene. The defendant didn't go into a police station and tell them what happened. The defendant didn't do any of it. He fled. That's one of the main reasons why they couldn't find this exact spot was because he takes off, and she's an upset woman, and they did the best they could with the information.
Right, it was valid questioning. Mr. Lamar, again, tried to imply that the police officers were not doing their job. Had Mr. Edgecomb stayed there, he could have said, this is what happened, and it happened in front of this location. He didn't. By all counts, You pretty much admitted, you said in your opening statement, he fled. He was 1,000 miles away in Kentucky. That was a valid redirect after the cross. 15 minutes. I expect.
Yeah, they set themselves up to fail there, but
we're off the record. Recess.
the reason why that's important is you have the Fifth Amendment right to remain silent. The prosecution can't comment on it. Generally, especially in times of interacting with the police or your post-arrest silence. In this case, there's no silence because Theodore took off. There's no disagreement that he took off, so it's not that he wouldn't talk to the police or he didn't talk to the police. It's just that never happened, so they can comment on things that didn't happen. If that didn't make sense, let me know. I can clarify it. Well, the courtroom just went down. They cut audio, so we're in a break right now, Mickey. It's going to be off for probably the next 15 minutes. Demetrius, these guys had been hired. Obviously, these are attorneys he was comfortable with. These are attorneys that also met his price point. I can only imagine both these guys from looking at what they do. They're not cheap. So, I don't think this is an issue of being prohibited by money. I just happen to think he picked a bad mechanic. He picked a bad attorney. So now at this point, it's going to be Theodore's turn. It sounds like there will be some officers that are going to testify. I'm not sure what they're going to testify to specifically, but I think it will go towards a narrative of there was work that could have been done that wasn't done, and then finally Theodore is going to testify. I presume he's going to go last. I think it only makes sense at this point. And yeah, I think that'll be the biggest thing. That's going to really be the last chance for him to save his butt. They had chances earlier, and they didn't go very well, so let's just hope his attorneys can pull it off today. And David, I think you're right. I think for him, part of the reason why he ran is he's sitting there staring at... David, I think you're right that he ran because, who's going to believe him? The whole situation went sideways at the drop of a hat, and yeah, I don't necessarily blame him for thinking, oh crap, I got to get out of here. Now, fleeing 7 states away and over 1,000 miles, that's a bit much. I mean, you could have laid low in town. But, it's too late to worry about that. He did what he did. Yeah, of course I feel for both families. At the very least, one of them's gonna suffer a loss forever. In the worst case scenario, Theodore gets convicted, and then both families are gonna be dealing with the loss forever. This is Wisconsin, so there is no death penalty. If Theodore loses, he's probably going away for life without parole. So, yeah, the stakes are about as high as it can get. So, we got 43 viewers. Hey guys, if you have other questions, feel free to put it in chat. Theodore Edgecomb's trial, we're right now waiting on the defense to begin theirs. We're about 10 minutes out. The prosecution just rested their case. They're done, subject to rebuttal. So now it's the defense's turn. This morning overall, I'd say it didn't really hurt Theodore too much. It really just established that we don't have a gun. There's some stuff missing evidence wise, but it's because Theodore didn't make that evidence available. It wasn't really, brand new stuff we didn't know. It was just them finally proving it. I will say to the defense, they did a pretty good job today. I mean, granted, they didn't do much, but for these guys, I think that's how you have to look at it. There were witnesses that didn't have anything to offer, so they just let that witness go. They didn't ask questions. They did stumble up a little bit when they asked a question to Detective Alvarado, and then the prosecution brought up the fact that Theodore didn't talk to him because he took off. So they opened the door and let the state point out one more time he fled. Yeah, Tim, I think, ultimately, yes, the chain of events started with the Clearmans in the car, but at some point, if it turns out Theodore didn't have the right to self defense to use a gun, ultimately the buck stops with the person who acted unreasonably or escalated. And I think Theodore is really losing that grip on self defense. It's starting to fall through his fingers. So hopefully they can introduce something that could show that there was a knife or there was a true real life threat. Anyways, guys, I gotta take 2 minutes. I gotta run an errand real quick. I'll be right back in 1 second. Sorry about that, guys. I'm back. So let's see what you guys are talking about. Precious Taylor, I don't think the judge has been super biased. His attorneys just suck. When you screw up like they do and you keep messing up in court, you tend to get, I mean, any judge will get upset. I mean, I've been that guy before. I've been in court, I've been in a trial, and from 5 minutes went from a judge saying, "Oh, hey, what's up, Mr. Martin," to, "I thought they were going to cut my head off." So, like I said, his attorneys are causing more problems than anybody else at this point. Yeah, Mr. D. Birch, that's the thing. He may be sounding rude, but he's been very professional. If you screw up in court, at some point, the judge is going to say not nice things, and everything he said's been within the realm of professionalism. It's just, sometimes, this is how professionals get treated. If you fuck up enough, the judge is going to let you hear it. Demetrius, you're 100% right. Had they just called the police or just let it go? Yeah, but as I stated, I think Jason Clareman was a bit drunk and didn't like the fact he got punked in front of his wife, so he wanted to go settle it. And as I said in one of my other videos, this is why you don't just go chase down people in the middle of the night. And if you're an adult, voluntarily getting into a fight over something as trivial as this, it's not a good bet. Yeah, Precious Taylor, I think as far as people have been lying, uh, Jason's widow has been lying, but once again, whether or not he was dropping N bombs or anything like that, none of it excuses Theodore ultimately unless he's got a knife and was about to shove him down the stairs. So I think Theodore's going to have to show how scared he was because right now we've got nothing to go off of. Oh, I don't think the judge thinks he's guilty. The judge just is tired of the defense counsel. I mean, this is a situation where they're screwing things up for their client. So, um, I think his demeanor is a lot how many judges would be handling things right now at this point. They'd be getting short with the defense. So, don't necessarily look at that as an importation of guilt at this point. Yes, he's been short from the beginning, but in some of the pre-trial hearings, his defense attorneys, like I said, these guys aren't the best and they've caused some problems. So yeah, the judge is already short with them. Would that give him enough to argue at on an appeal? I certainly would be arguing it if I'm his appellate attorney, but we'll have to see how that shakes out because he might not need one. He might get acquitted. So, fingers crossed that we don't have to get to that point.
The state rested, subject to rebuttal. First of all, is there a motion at the end of the state's case?
Yes, Judge, we are moving to for a directed verdict. The state has charged us as a first-degree intentional homicide. Sorry, not a directed verdict. I'm saying a motion to dismiss at the end of the state's case. The state has charged us as a first-degree intentional homicide. This charge was increased after previous charges for reckless. I know that all facts have to be looked at favorably, in the light most favorable to the state in this case. With the evidence that's been submitted is the video and some of the testimony about one gunshot. In our view, that's just simply not enough to indicate an intent to kill.
Jesus Christ, man, get it out.
So we're asking the court to dismiss at this time.
Mr. Hubner?
Your Honor, at this stage of the proceeding, the evidence must be viewed in the light most favorable to the state. There is one shot, that is true, but it is a shot to the face. The defendant shoots a firearm into the victim's face at close range. Intent to kill can mean either intent to kill or the individual, it's practically certain, would cause the death. When you have a gun and you point it at someone's face and you put a round into their brain, it is practically certain to cause their death. Also, a witness who saw this described it as cold-blooded. That, in the light most favorable to the state, is evidence to proceed on this charge. And even if you were to accept what defense counsel stated, the remedy then would be for the court to amend the charge to what there is evidence of. But in this case,
actually, no, I think that the remedy would be to
evidence
dismiss
of
the case.
Intentional homicide to go to a jury.
Right, I agree with that. Taking the evidence in the light most favorable to the state. The testimony is that
He shot the guy.
the defendant,
That's
as the
it.
state
There's no
noted,
way that's getting dismissed.
at least allegedly pulled out a handgun and shot Mr. Clearman in a very close range. The testimony was 2 or 3 feet, maybe closer, maybe a bit further away, and he put a bullet literally between his eyes and in his brain. That is enough to proceed. The defense motion's denied. Who's the defense first witness?
Judge, we would call Officer Raymond Debraska.
Raymond who?
Debraska, D-E-B-R-A-S-K-A.
All right, I'll bring the jury in. You can come up, officer.
So, guys, yeah, it should look very damning. The state just got over presenting all their evidence of guilt, so it should look like Theodore's kind of toast. This is halftime. They have a chance to turn it around. The odds are not in their favor, but I certainly think they can do it. Also, getting a motion to dismiss at that time, you always make one as a defense attorney. You rarely ever, if ever, win it, but you always try to push for it because you might. Waiting on the jury. I'm not sure. I don't know how many more fucking detectives there are in Milwaukee, so this will be interesting to hear what this detective has to say.
The jury's coming in. You can remain seated, please.
That's nice he doesn't make everybody stand for the jury, because usually, in every courtroom I've ever been in, you have to stand for the jury and give them some respect.
All right, the jury's back. Ladies and gentlemen, as I said, the state rested their case. The defense has now decided to call witnesses and put on a case. This is a defense witness. Sir, if you can stand and raise your right hand, please.
Do you solemnly swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Please be seated. State your full name, spelling first and last for the record, and you may remove your name.
Officer Raymond Debraska. It's Raymond Debraska.
Hey
Go
guys,
ahead.
real quick,
All right, thank
like
you.
and subscribe if you're here. I'd
Officer
appreciate it.
Nebraska, can you give us a brief overview of your current employment at the Milwaukee Police Department?
I'm a police officer with the Milwaukee Police Department. I'm currently assigned to District 1
Some slick back
Okay,
hair.
How long have you been an officer with the Milwaukee Police Department?
since 2012.
2012. And currently, what is your title there?
Police officer.
Okay, and so you've been a police officer since 2012, or do you have any other prior experience before that?
I've been a police officer since 2012. From 2009 to 2012, I was a police aide.
Okay, can you give us
Aide.
police aid? As a police officer, can you give us also an overview of what some of your duties are?
Responding to calls put into service for us, patrolling, doing traffic stops, things of that nature.
Okay. Would you be known as like a field officer?
Yes.
Okay, and do you have a partner?
Yes.
And who is your partner?
At that time, it was Officer Esther Kremserova.
Okay. So then let's talk about at that time, September 22nd, 2020. Do you recall that evening and why you were dispatched to a certain location?
We were working that evening, and we were dispatched to a shooting at the intersection of Brady Street and Van Buren Street.
Okay. And do you remember approximately what time you arrived there?
Approximately 8 p.m.
Okay. And that would have been shortly after the shooting, right?
Yes.
Okay. And what was your role that evening along with Officer Kremserova?
Officer Kremserova, I believe, stood near where the shooting victim was, and I proceeded to put a caution tape around the area, and then I was assigned other duties throughout the evening.
Okay. Now, are you familiar with that general area, Brady and Holton?
Yes.
Okay. And have you done some, police work?
So he was
there,
one of the first
such
guys
as
on scene.
Patrol or any other traffic duties you may have, or any other investigations prior to this incident?
Yes.
Okay. And then on that night, you were dispatched there, and you said that Officer Kremserova was involved in, I think, being there, right? It was one of the first responders. Is that correct?
Correct.
Okay. And where were you at that time?
While she was doing that, I started to put up caution tape around the area to keep any passerbys from coming into the immediate area.
Okay. And is that called maintaining a perimeter?
Yes.
Okay. And did you have any other roles that night?
Yes. I was instructed to call back those who had reported the incident, and as well as canvass around the area to check for any other witnesses.
Okay. So, do you remember, so you mentioned that one of your roles was to interview some of the witnesses that were there on scene. Do you remember the names of those witnesses?
I remember speaking on the phone to Rod
Hey,
Trell
Jeffrey,
Cameron
is this better?
and a Stephanie Trotter.
Okay. Now let's talk a little bit about your other task that night. So you mentioned that you were canvassing. Can you give us a brief description of what it means to canvass an area?
So when an incident occurs, something like this, generally we'll check any businesses in the area, any houses that are in the immediate vicinity, see if there were anybody that happened to be looking out their window and saw the incident happen, or if there are any cameras in the general area that may have caught the beginning or after, or maybe the incident itself.
Okay, and how was it determined that this was a task you needed to do? Were you given an assignment by a superior officer, or was it just something that you figure out?
At incidents like this, there's supervisors that are on scene or the detectives, and they'll just kind of divvy out the different tasks that need to get done. And sometimes you'll get this, and sometimes you'll get something else.
Okay, do you recall what your canvassing assignment was specifically?
I was told to canvass the residences and businesses to the east of the intersection of Brady and Van Buren.
Okay, do you recall? So let me rephrase that. So your assignment was to go down Brady to the east, then canvass that area?
Yes.
He was looking
Okay,
for
do you
camera
recall
footage.
how many, like, what kind of distance are we talking about in terms of canvassing?
I believe I did to the next intersection, and I'm sorry, I can't recall the name of the next street that is just east of there.
Okay, well, would it refresh your recollection to review some maps of the area?
Yes.
I'm going to show you what's been marked as Exhibit D5 previously. Do you recognize this? I guess we'll
man
call
bun.
it a poster board. Do you recognize this, sir?
Yes, it appears to be an overview of the area.
Okay. And
Officer
you
Brody.
see Brady and Holton Street, the intersection.
Yes, I do.
Okay, if you want to point that out to us, just to be clear. Okay, and officer, from your recollection, and for the record, Judge, he pointed at the previous X mark that's already there. That was,
Officer, is that correct?
Yes.
Fine.
and Officer Nebraska, can you tell us from your recollection maybe about how far you were canvassing that evening?
I canvassed up to the intersection with North Cass Street,
Okay.
stopping at the restaurant Casablanca.
You guys are welcome.
Okay, so maybe about a block or so?
Yes.
Okay, did
If
you
you guys
ever
like
come
it,
up to Marshall Street
like and
from your
subscribe would be great.
recollection?
Not that I recall.
Okay. All right. Thank you. You can just go back to your seat.
Imagine getting arrested by that guy, Playmaker.
And I'm going to show you what I marked as exhibits D26, D27, and D28.
Dead air. Dead air. Come on, attorneys, let's go. Uh-oh. Looks like he's about to screw up. I think this is going back into their conspiracy of the police not trying to find everything. If this guy only went about a block in from the shooting.
Officer, I'm going to show you what's marked as exhibit D26, D27, and D28. Can you take a look at this and let us know if you recognize this?
Yes, it's a series of 3 overview maps of the area.
Okay. Now, can I have it down in the back?
Yes.
Now, just to clarify, let's move that. These maps are of the same general region that we were just looking at on the poster board, right?
Yes.
Okay. Now, I just want to focus your attention on the streets here, not necessarily some of the markings of the buildings on this map. So, officer, you said that you had basically gone maybe a block or so as part of your canvas. And do you recall maybe how many locations you had canvassed at, such as talk to witnesses or rang doorbells?
Maybe 5 to 8 different businesses and residences, I believe.
Okay. Do you recall writing a report about all the areas that you canvassed?
Yes.
Okay. Now, would it refresh your recollection to review your report to know exactly which addresses that you had checked?
Yes.
Okay. You just take a look at that and let me know when you've had a chance to look at that thoroughly.
I see you guys talking about Nick Ricada. At least you're not telling me I suck compared to him, so I'll take it.
Okay.
Okay, you had a chance to look at that?
Yes.
All right, thank you. So, your assignment officer, and by the way, did that refresh your recollection?
Yes.
Okay, so your assignment that evening was to go from 706, well, let me rephrase that. So you stopped at 706 East Brady Street, correct?
Correct.
And then you made your way eastbound on Brady, and the last address that you canvassed was 816 East Brady, is that correct?
Correct.
Okay. And do you recall how many different locations you may have visited?
10 locations, all on the north side of the street.
Okay. Now, I'm going to flip over to Exhibit D27.
Can everybody hear me? Because it sounds like somebody's saying they can't hear the trial.
All right, officer, can you see that from where you're at?
Yes.
Are you able to see any of the numbers here? If I were to zoom in.
Yes.
Okay. Now, you mentioned that 816 East Brady was the furthest east you went that night for your canvass, right?
Yes.
Okay. So, 816 East Brady, would you agree with me?
You should be having the witness mark this, not yourself.
That 816 East Brady would have been somewhere in, if I were to mark an X, somewhere in this area?
Yes.
Okay. So that's about as far as you went, and you had started at 706 East Brady, which, would you agree, is right here where I'm placing the X?
Yes.
Okay. So is that accurate in terms of your route that evening for the canvass?
Yes.
Okay. As part of the canvass, besides talking to witnesses, potential witnesses that is, does that also include observing cameras?
Yes.
Okay. And why is that important?
We check for cameras to see maybe flight paths, or for after an incident occurred, maybe the people fled this direction and passed the cameras, or maybe the cameras had actually caught the incident take place. So we always try and check cameras in the area of major incidents like this.
Okay. Now, were you able to speak to any witnesses that evening?
During the canvass, I spoke to a couple individuals, nobody who had actually witnessed the incident occur. Spoke to a couple business workers along the route as well.
Okay. Were you able to retrieve any sort of video at that time?
No, not at that time.
Okay. But then you did complete a report about that, correct?
Yes.
Okay. Was there any other follow-up on your end to do any further canvassing beyond what you did that night?
No.
Okay. Now I'm going to turn to Exhibit D28. So can you tell us what you see here?
an overview of the area further east down Brady Street.
Okay, and just to be specific, can you tell us what blocks it's depicting on Brady Street, or what intersections?
Brady Street from just west of North Marshall Street down to east down to North Humboldt Avenue.
Okay. And are you familiar with the restaurant Dynamite?
Yes.
Okay, do you know which intersection that is at on Brady Street?
East Brady and North Astor.
Dynamite.
Okay, now this map, does it depict Dynamite on it?
Yes.
Okay, would you say that that is accurate of how it depicts it, as if I were to place an X here, that's generally, would you
Once
agree
again,
that
let the
that
witness make
is
the
the
marks on
location, or
exhibits.
right under the
That's a
location of
better way.
Dynamite?
Yes.
And just to be clear, that is the kitty corner across from Glorioso's, is that correct?
Correct.
Okay. Are you aware of any other officers being involved in this canvass that night?
There were other officers involved. I can't recall which officers it was.
Okay, but it wasn't Officer Krem Sarova, your partner, right?
No.
Okay. Did you have any other tasks in this investigation for the for the shooting involved in this case?
No.
Okay. All right, thank you. Nothing further. And at this time, Judge, I'd move D27, D28, and D26 into evidence.
Any objection?
No.
Fine, received. Cross.
Please spell your partner's name for me, please.
First name is Esther, E-S-T-E-R. Kremzerova is K-R-E-M-S-E-R-O-V-A.
Officer Kremserova testified at the beginning of the trial for the state, so she's already gone in case you were wondering where she was. Yes, Tracy, he's very, very dry.
Sorry, had to make sure we got everything right there. Officer, you went down the street to see what cameras there were, is that correct?
Correct.
You went to Zanya's Pizza to see if you could get that camera?
Yes.
Were you able to get it?
No.
You made sure people know, right?
Yes.
So that's why detectives came out and were able to get that.
Yes.
Casablanca, you went there, you tried to get that security camera footage.
Yes.
And that would be why another officer went out there, is that correct?
Yes.
And that officer sat there for a long time watching a bunch of cameras. If you even know.
He has no idea.
I don't know.
Okay. And because of what you provided, officers in the days following it went to these cameras to see if they could find them.
Yes.
Okay. Did you try to see if you could find anything in the block east of this incident?
Further down from where I stopped?
Yes.
No, I did not.
No, I'm saying in the area that you canvassed. Were you able to find any camera footage that you were able to watch?
Oh, yes.
And did any of it capture the incident?
Not the incident as it occurred.
What about the punch? Did it capture that incident?
No.
What about an incident that may have happened before, swerving? Did you see any of that?
No.
You were looking for whatever you could find
Yes.
and found nothing.
No.
And when you couldn't find anything, you made sure detectives could follow up on it.
Yes.
You also spoke to 2 911 callers.
Yes.
And you also interviewed any person that seemed to maybe have seen anything. Is that correct?
Yes.
Did anyone see anything?
On my canvas? No.
Did you talk to anybody that may have seen a suspect running away?
I recall talking to an individual that was near the perimeter of the scene who stated that he had seen something. I gathered his information and passed it along to the detectives who then took over that.
And if you had seen anything, detectives interviewed him. Is that
Yes.
correct? So you talked to every person you could,
Yes.
and most of them had nothing except for one guy, and you passed him on. Don't even know if it was relevant.
Yes.
Thank you. Nothing else.
Defense? Anything?
Just a couple of follow-up questions. So it's just at no point, though, in your task that night was to Well, let me back up 1 second. At any point in time, Officer Nebraska, did you speak to the wife of the deceased in this
Objection,
case?
Your Honor.
Outside scope of.
Objection.
On what basis? Did you have any opportunity to,
Forgot to ask it on
in addition
direct.
to canvassing, try to locate the area that an initial encounter had occurred between the two parties in this case?
No, I did not.
Okay. Thank you. Nothing further.
Stayed.
No.
All right, you can step down, officer. Thank you.
There was no point in
Defense,
that
next
reading.
witness.
Judge, I believe our witness is here. It would be Lorenzo Hernandez. Just one moment.
So this is going back to the defense's theory that the police never looked for everything and that there may have been actual evidence they let spoil and disappear out into the wild. I don't think they've got anything because he doesn't know what anybody else did. He only knows what he did. So, well, like I said, maybe they're going to produce the rest of that and show us there's footage from that Dynamite restaurant. But if that was the case, the prosecution would get it as part of discovery. Little Miss, it's in the case of Wisconsin, yes, Theodore punched Jason Clearman in the face first, but then he rode off, so he effectively retreated, so he's no longer the aggressor. Jason coming after him makes him the aggressor, but
Judge, our officer isn't here.
with self-defense, it has to be proportional.
One more witness out there. Just one moment.
And
Call whatever you have.
and the prosecution's claiming you don't get to meet fists with a gun, but that's not the entirety of the analysis. It's very fact specific. Sounds like they're having some issues with witnesses. This happens a lot. You tell somebody, "Hey, be here at 11:30," but you get done ahead of time. Things go faster than you anticipate. So now it's 11 o'clock and you're sitting there holding your hands for a half hour. Yes, Playmaker, you're right. He does not say rude things. He just says them very tersely. There are a lot of judges this way. There are a lot of judges who are very pleasant and keep that demeanor the whole time.
You solemnly swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? So help you God.
Yeah. All right, you can be seated. Remove your mask, please. State your name, spell your first and last name for the record.
Patrick Tivnan, PatrickTivnan.
Holy shit, he looks thrilled to be here.
Officer, you're gonna have to use the mic. Speak up. Use your outdoor voice. Go ahead.
Good morning, Mr. Officer Tiverton. How are you?
Good morning.
All right. Now, I want to first start just with your experience. How are you currently employed?
I'm a patrol officer at the Milwaukee Police Department in District 1.
I'm a policeman.
How long have you been employed by the Milwaukee Police Department?
3.5 years.
Officer Eeyore.
And what training did you have as it relates to becoming a Milwaukee police officer?
I attended the Milwaukee Police Academy, which is approximately 6 months.
And what consist of that training?
Well, quite a few things.
If
They
you could
teach
just
me police
name
stuff.
generally areas that you were trained on over the course of those 6 months.
Sure. Investigation, professional communication, constitutional law, firearms, emergency vehicle operations, first aid.
Yes, Elizabeth, Officer Pros.
And as it relates to investigation, what kind of training was provided as far as it relates to performing investigations?
They teach us to ask questions.
Quite a bit. Is there more specific?
Well, sure. Let's go in specifically to homicide investigations. Did you receive training related to homicide investigations as part of your 6 months of training?
Yes.
You're under arrest. Put your hands up.
And what areas were you trained in as it relates to homicide investigation?
We did a training regarding a scene investigation, how to describe a scene, and measure various distances of evidence and objects, or how to preserve evidence. If there's evidence located, somebody has to stand with it, wait till it's photographed, don't touch it, and that sort of thing.
Okay. And let's talk a little bit about preservation. Why is it important to preserve a scene upon arrival?
So the photographs that are taken can show everything in the state that they were in at the time. That nothing has changed prior to an official record being taken of it.
Okay. And why is it important that the way that the scene is at the time an incident occurs, that it doesn't change? Why is that important?
Because that would give it the truest picture possible of what took place.
Now they're going to claim evidence got spoiled.
And what kind of measures does the Milwaukee Police Department provide to ensure that a scene is not contaminated in any way upon arrival?
Sure. We typically set up a perimeter with yellow police tape, and it's called scene security, and try to ensure or at least record that nobody crosses that line unless permission is given to them for a particular reason.
Okay. And is that also to ensure that items that are on scene are not removed from where it currently was at the time?
Yes.
Okay. And why is that important?
Again, going back to your prior question, it's important to preserve the evidence and take photos of where it is at the time the incident occurred, to have the most clear picture of where everything was.
Okay. And would you agree that if an item has been removed from a crime scene, that would tend to compromise that crime scene?
Prior to that being authorized by an investigator, yes, I would agree.
Okay. Now, as it relates to investigating a homicide investigation, are getting witness testimony important?
Yes.
And why is that important?
Objection, Your Honor. They don't get testimony. Testimony is in court. They get statements. They get statements. Sorry, he keeps taking my microphone.
All right, the objection is, the question was, did you get witness testimony? Testimony occurs in court. He may have got a statement or spoken to a witness. So yes, let's just move on. Go ahead.
Officer Tibbin, is it important to get witness statements at a scene of a homicide investigation?
Yes.
And why is that important?
Jeffrey Storage break the bills
because
in
they would
half.
provide a potential perspective on what happened.
Officer, how much Valium have you taken today?
And Mr. Tibbin,
Half a bottle.
you talked to several witnesses as it relates to an incident on September 22nd of 2020, correct?
I believe 2.
Okay. And do you
My
recall?
recollection.
I'm sorry.
One at a time. What was the answer?
I recall speaking to 2 witnesses.
And who were the 2 witnesses that you recall speaking to?
One was Mr. Perez, who I believe has already testified, and the second was a male. I don't recall his name at the moment. I wrote it down at the time, but he did not have anything relevant and told me something that was that I judged to be irrelevant to the scene. And I wrote his name down in my notes, but did not include it in a report. I do not recall his name today.
Okay. I want to go now to a defense exhibit. Give me one.
So, guys, the reason why the judge is stomping all over him is you
50,
have to
we're
be
just
precise
connecting.
with questions.
The media at this time.
Your Honor, can you give the defense evidence control?
As far as the manslaughter issue, guys,
15? Yes,
Issue-
number 15. All right, so I want to
Goddamn
just kind of go
Streamlabs.
through.
Killing me.
You recognize this to be your body-worn camera on September 22nd of 2020?
Yes.
Okay. All right, so I want to just kind of walk through what occurred on that day as part of your investigation. We could go to 6 minutes, please.
Talking about body camera, he hasn't laid any foundation for a body camera.
Ready?
6:03, is that okay?
Yeah, that should be fine. Now, I want to just stop right quick. Is that Mr. Perez that you recognize that you're?
Yes.
Okay. Go ahead.
Playing at 6:03.
Your Honor, I was going to object to hearsay and cumulative. This has been played multiple times before.
I don't know if this
Your Honor,
specific
this
one
is the
has.
Tiverton video. This has not been played at all in this trial.
Good
This
point.
has been. You played this with this witness, with Mr. Perez.
Well,
Well,
I don't
we're
remember
using
this.
it for a different purpose here. And
What purpose?
basically, Mr. Tiverton does not, Officer Tiverton. Officer Tiverton has obviously stated that he has some recollection issues as it relates to his investigation on that date, and obviously this video would tend to.
And when did the officer testify he has recollection issues? Those words did not come out of his mouth.
He just stated that he does not recall the second witness that he talked to.
And that would be fine if we go to the second witness.
Right? He said he recalled this witness. You can play it for now. I'll see if it's relevant. But as I said, to both sides, this is starting to get cumulative. It's starting to get repetitive. And that's going to stop.
Yeah,
Go
this
ahead.
is poorly planned, poorly organized. This hurts Theodore a lot.
Is the bicycle on the street or the sidewalk? The bicycle on the sidewalk. Is he on the sidewalk the whole time? Getting the sidewalk on break? Hands on my ear? So this deportation, it's like, describe a bit more about confronting. What's it doing?
They kept on like stopping, going, and that's when they stopped right there.
Okay, stand by. I'm just trying to get. You can't hear if they're like talking to him, but it, okay.
And then the passenger in the Kia Forte gets out.
I can't even hear what the hell they're talking about.
Okay, so during that conversation, do you recall being interrupted by this second individual that you recall talking to at some point?
Yes.
Okay. If we could fast forward the video to approximately 13 minutes and 17 seconds.
13 minutes and
17 seconds.
Guys, I'll explain why I don't think this qualifies as manslaughter when we get a second of time.
okay, it's queued up at 13:17.
Okay, you go ahead.
2554. Check your address. All right, I need you to hang tight for me, okay? Thanks. Well, that's my understanding. Honestly, I can't verify that, but that is my understanding. But we can't tell if any other people saying around. Of course, yeah. But I believe that is the case. That is crazy.
That's why I stay out of trouble before I covered 3 times.
Officer Tiverton, do you recall, is that the conversation you recall continuing with Mr. Perez after being interrupted by an individual who claimed to have information?
I couldn't tell you if the clip that you just played was pre or post being interrupted by the other individual.
Okay, and that individual had.
This is
Yes, ma'am. The clip that was just played, I don't know if that was before or after I was interrupted by another individual.
And do you believe that individual had a bandana on at the time that he came up to you?
Yes.
Okay. And how did you determine that the information that that individual had was not pertinent to this case?
He described two males that he overheard speaking in a vehicle. I believe he stated about a block and a half away in an alley to the
he's
southeast.
talking to Jose Perez, a
And
witness who
nothing that they
testified
said
on Friday.
was specific regarding this incident. And at this time, I had already heard from Mr. Perez about a vehicle pulling up and his description of the incident. What this other man was talking about two males that he overheard speaking in an alley a block and a half away, did not appear to be relevant at all.
Okay.
In
And do you
my
recall?
judgment.
Okay. And do you recall taking his information down as to his name and contact information?
Yes.
Okay. And are those the two individuals that you recall as in the gentleman that would have the white bandana on?
Yes.
Okay. All right. If we can now go to 42 minutes and 32 seconds. 30 seconds is fine. And that, I'm sorry, we can stop right there. You could back up a couple points.
Those guys
so
in
we
the
can just
alleyway are
confirm.
not going to be
Right
credible
there.
to this
Is that the
case.
individual that you described as the second gentleman that had the bandana on?
Yes.
Okay. At this point, we can go to 42 minutes and
None
30
of this
seconds.
occurred in an alley.
All right.
Elizabeth, yes, I think the wife avoided answering questions directly because she was trying to church things up and make her husband look good. That was her way. I think she thought she was helping, but we all know that Jason wasn't going up there to talk.
Your Honor, while
You
they're
know,
getting
we knew
that
there was
set
gonna
up,
be a
Can we
fight.
have a brief sidebar on this? Sorry.
Yeah, the judge is not thrilled. Neither am I. So they're going to have a discussion about this video. I don't know. Lil Miss and Jackie, you guys were talking about why this is a manslaughter. Yeah, manslaughter occurs like in the heat of the moment, but during a fight, you've decided you're going to fight somebody. And I think for Theodore, the fight hadn't started yet when Jason approached him, so I think they're making the decision. He intentionally decided, you know what, I'm going to dust this guy right now and get it over with. I assume so, but you know what? We could probably find out during their closing a little more about their theory to this case. Holy shit, 211 viewers. Well, guys, if you've just tuned in, my name's Sean Martin. I'm an attorney out of Cleveland. I run this channel. If you guys like what you see, please leave a like and a subscription below. I plan on covering a lot of stuff coming up, so yeah, throw in a question if you have any. Now, I will say, as far as the way the judges treated defense counsel, there have been pretrial hearings. They have screwed up a lot. This is not their first time. There have been a lot of problems. So the judge is kind of at his wit's end with these guys, but it's not just their first day. This isn't their first screw up. This is, screw up number 500. Lil Miss, she was very evasive during the prosecution's questioning of her on direct. She wasn't answering questions in a way the prosecutor was prepared for. In fact, I'll probably cover this tonight when I do my day 4 and 5 recap. There were multiple spots where the prosecutor was himself thinking, oh crap, I didn't ask you that. You didn't tell me that was going to be the answer. So she was being very evasive to everybody. Like I said, I think she was trying to help in her own way, that she thought churching things up, that Jason said, what the heck? I dare say, good sir, please do not strike me again. Instead of what he said, I think she thought that would help. So she was being evasive to everybody. They better hurry up. I think Officer Prozac's going to fall asleep up there. Little Miss, the fight... Well, think about it this way, if I can try to explain it. Like you're at a putt-putt course and there's the windmill going along and you have to get your ball through it. Every time the windmill blocks your shot, self-defense is closed. And every time there's an opening, self-defense is open. Self-defense can open and close, go away, reappear multiple times in a situation. So, yes, once Theodore punched him, he no longer had the right to self-defense. But once he ran away on his bicycle and got away from him, he now had the right to self-defense. He had disengaged. So, yes, if you can keep punching somebody, leaving and punching and leaving, then punching and leaving, it can ebb and flow. It's like the tide. So, he regained it back when Jason confronted him. I just don't think he had the right to use lethal defense at this point. The evidence is very bad at this point. I mean, I still think he can make the argument, yeah, it was dark, I was at the edge of a staircase, this car rolled up on me really fast, this big drunk guy screaming at me and was about to square up on me, and I was in fear of my life. And that could be an argument he makes, but that's not the best one to have.
All right, we had a conversation off the record. We can continue for now. I'd like this to be relevant evidence, and we're not going to refer to people as witnesses that are not actual witnesses to this case or this incident. That's basic trial practice. Go ahead.
Officer Tibnan, you indicated that there were two individuals that you followed up with as far as that you believed had information relevant to this case, correct?
Mr. Perez and the male with the bandana on his face.
And you determined that the second individual with the bandana did not have information that was pertinent to the case. Is that correct?
Correct.
And there were not any other individuals that you believed on September 22nd, 2020 that had information relevant, correct?
Correct.
All right. At this time, I want to now go into defense 15 and play at 42 minutes and 30 seconds.
Your Honor, I believe a question should be asked before we're just playing video.
Yes, the question should be asked. We don't play random video without some verification, without a point for the jury where it's going.
Officer Tibnan indicated that there was not a third individual that you talked to on September 22nd, 2020 that you thought could potentially have information relevant to this case, correct?
I recall speaking to two individuals.
Okay. And do you recall, and those are the only two individuals that you identified as potentially having information relevant to this case, correct?
Correct.
All right. At this time, we would like to now go into defense 15 from 42 minutes and 30 seconds.
What happened there was proper foundation was not laid to watch the video. You have to show a reason why you're watching the video and why it's relevant. That's kind of the layman's terms of relevancy and foundation.
You got the volume on?
He was standing over there for a while now. Tony? I'm standing with this gentleman, Mr. Perez, as a witness, but across the way, there's a gentleman standing there. He's been standing there for a while. I'd like to go up and ask him if he saw any of this, if he's been there for a while.
Okay, can I make it quick?
Did you all right? All right.
Can you stop right there?
Maybe great.
So at this point, Officer Tibnan, you identified a third individual that could potentially have information relevant to this case, correct?
I did not identify him.
Well, you saw a man that's standing over there, and you stated that he's standing there for a while, and you would like to go talk to him, correct?
Correct.
Okay, continue.
Playing at 43:15.
All the way here.
I'm assuming once they're done with this gentleman, they'll come talk to you, okay?
Jackie, are you talking about my mic volume or the volume of the feed?
For a while. Maybe I should ask him. Hey, sir, did you see anything?
Oh, fuck that.
No? All right.
We got the caller, we got the gentleman, we got his wife.
Okay.
We got actually people that were.
Can you stop right there?
All right.
I don't know what he said, but
Okay, so Officer Officer Tivenin, you then go to Officer Michelli. Is that correct?
Correct.
And you asked him for permission to go talk to another gentleman that was standing over there with potential information to this case, correct?
I wouldn't call it permission. Just put it in discussion. The possibility of talking to another person who was on the perimeter of the scene.
Okay, discussion. And part of that discussion, Officer Mahalik then says, fuck that, we got enough, correct?
Correct.
And he further says, we have the wife, correct?
Correct.
He says, we have someone that called 911, correct?
Correct.
And he says, we have this gentleman, correct?
Correct.
And because Officer Mahalik, was that the determining factor as to why you didn't pursue this third individual who was standing there who you identified?
No.
What was the reason why you didn't go provide information to seek the information that this third individual could potentially have after Officer Mahalik says, fuck that, we got enough?
When I arrived on scene, then Sergeant, now Lieutenant Tim Garkey told me to do scene security, which is typically a standalone task. I was doing that, and as seen in the video, Sergeant Diana Barkus with the red hair came and told me to start interviewing people. That was fruitful and a good idea on her part, but at the time, I found that challenging because scene security and canvassing witnesses is typically two separate tasks. Once Mr. Perez had been identified as a very
witness.
Would appear to be an important witness, I had a new task to continue scene security, as then Sergeant Garkey told me to do, as well as standing with Mr. Perez to make sure that he didn't speak to any other witnesses and wasn't contaminated in a sense prior to passing him off to a CIB
He's getting
detective.
more lively as he speaks.
So I had two tasks, and the idea of taking on a third task not seemed possible to do three tasks well, correctly. So I returned my attention to the primary responsibility of scene security, as well as preserving and staying with Mr. Perez as a witness.
Now, Officer Tivenin, at the particular time prior to you saying, I see this gentleman over here, you were interviewing potential witnesses, correct?
Correct.
All right. So that was your current task at that moment, right?
I had multiple tasks at the same time.
Okay. And going to talk to a third individual whom you identified as an individual who might have seen something, that would be consistent with interviewing potential witnesses, correct?
You could say that, correct.
And you would agree that there's never a point in a homicide investigation where a police department has enough, correct?
Objection, Your Honor. Speculation?
Sustained.
Officer,
Also argumented. Never appoint counsel. That would mean, come on.
Officer Tivenin, it's important to talk to every potential witness available in a homicide investigation, correct?
I would agree, yes.
And at this point, would you agree that this is somewhat within the first hour that this incident took place, involving force being used against Mr. Clement, correct?
I don't recall the actual time frame, whether this was in an hour or it was a long scene. I don't know when this, how far into my arrival on scene or to the incident this is. So I can't answer that specifically.
Now, you're familiar with the standard operating procedures of the Milwaukee Police Department, correct?
Yes.
And in those standard operating procedures, it also puts a duty on you as a homicide patrol officer to talk to every
Objection,
potential
Your
witness.
Honor. There is no homicide patrol
Yep.
officer in the Milwaukee Police.
Come on, gotta be specific, bro.
There is no such thing. He said he's a patrol officer that responded to a scene. He outlined for you his duties, various duties as an officer. There's no homicide patrol officer. There's no such thing.
Officer Tivenin, as a patrol officer investigating a homicide investigation, it is important, based off the standard operating procedures of the Milwaukee Police Department, to talk to every witness that could potentially be available, correct?
I'm not aware of the particular SOP or stanza in SOP that you are referring to, but as a general principle, what you're saying, I would agree, yes.
Now, it's also important to keep your body-worn camera on at all times when investigating a potential homicide, correct?
there's an exception in our SOP that we can turn our cameras off for particular purposes.
Okay. And those particular purposes would include if you're concluded your role in that investigation, correct?
That is one of them, yes.
Objection, Your Honor, relevances to this line.
At this time, I would like to continue playing the conclusion of the video, please.
Objection, Your Honor, is to the relevance.
How's it relevant?
Because Officer Tiverton cuts his body camera off immediately after these remarks were made by the fuck that we got enough. His body worn
That's
camera
not
goes
true.
off. The video will prove it. If we can play it.
No, you can't right now.
Actually, after that assertion, let them play it. It's not what happens. That's fine. Let them play it.
Ooh, somebody's calling a bluff.
They withdrew their objection.
Sorry, that was loud.
You can go back about 5 seconds so we can get a full.
No, play from this portion.
Play it from where it is right now.
Ooh.
All right, fine.
Drum roll. Tension, tension, tension.
That's the hard part, is trying to keep the family away.
Yeah,
That part sucks.
yeah. Is he still there? Is he still there? They fucked me up now.
Jack, are you live?
Yeah. Caught it or?
Yeah, for a little bit.
Any video discuss the officer.
Now, Officer Tiverton, at this point, Officer Mahalik asks you, are you live, correct?
Are you what?
Live.
I didn't hear that exact bit, I'm sorry. Could we replay the portion you're referring to?
Sure, we can go back.
There's, guys, that sound from the body cam, it's very hard to hear. I can barely hear it myself, so I don't know what to do about that. We're watching a stream of something being played on a TV.
It's playing at 4350.
Sorry, Susan. Sorry, Barbara. I have headphones on. I can barely understand.
Is he still there? Is he still there? They fucked me up now.
Right now, these cops are just bullshitting. There's really nothing to talk about.
Caught it or?
Yeah, for a little bit.
Any video discuss the officer.
Now, at that point, did you hear Officer Mahalik ask, were you live?
I heard the word live. I'm sorry, I can't hear the first two words that he's saying.
And do you recall saying, should I cut it, after he asked, are you live?
Now that you mention it, it sounds like that's what I said, yes.
No more questions for this witness.
Okay, so first of all, defense counsel was stating that you cut your body cam immediately afterwards. That's not what happened, is it?
No, it's not.
Just so we're clear, that assertion is just not what happened. To begin with,
Yep,
you guys
showing
were
that the
talking
defense
about
is
the hard
lying
part,
because
you
they
and Officer
weren't
McCallum.
precise.
Do you remember hearing that?
You've got to be
Yeah.
precise.
They don't mention this at all, but that's the very next thing you guys talk about. What's the hard part?
He was talking about scene security regarding the family and keeping them outside of the perimeter and
What's
trying
so
to...
hard about keeping a victim's family outside the scene?
Well, it's very emotional because they're clearly in an extreme emotional situation, and we have to sort of enforce the perimeter of the scene, contrary to what their emotions want and some very reasonable emotions that we can understand. Yeah, we got to preserve the scene and stick with that.
And this is something you guys are talking about at all the scenes you deal with. One of the hardest parts is making a family stand on the other side of tape while you're looking at their dead loved one.
Yes.
And then you asked, is he still there? Is that correct?
Yes.
Who are you referring to?
The deceased.
Had you ever gone up to the body?
When I very first arrived, yes, and I did once again before I left. After this, at some point, yes.
Okay. And so then you guys turn off the conversation and have a private conversation. Is that correct?
Yes.
Okay. Now, I just want to be very clear about this. Defense counsel was stating about this third person that you said, I see him standing there for a long time, right? Is that, you remember that?
Yeah.
Okay. Did he ever wave you down?
No.
Did he ever make eye contact with you and indicate he wanted to talk to you?
No.
Did he ever glance at you and make it seem like he wanted to talk to you?
No.
Did you have any indication whatsoever from him that he had any information?
No.
He was there.
Correct.
When you do crime scenes, do people sometimes stand and gawk?
Yes.
Do you talk to every single person you see outside the tape?
No.
Okay. Additionally, officer, the second person, he was very aggressive about trying to wave you down. Is that correct?
Yes.
Mr. Perez came and identified himself as someone that had information.
I don't recall that he identified himself to me, so I can't say exactly the initial when the
But to
MPD
somebody.
came in contact.
Sorry, I apologize. But to somebody, correct?
Yes.
Okay. So the two people you talked to were people that stated we had information.
Yes.
Okay. Now, when you go speak to this second guy, the guy who, just to be clear, he's talking about overhearing two African-American gentlemen in a car talking about someone geeking, right?
Yes.
And then popping them.
Yes.
He thought that maybe these two guys in an alley maybe did something to someone who was geeking.
That's what it seemed like, yes.
Doesn't seem at all like it's describing the incident that you have heard from Mr. Perez and other witnesses.
Correct.
Okay. Now, when you go speak to that guy, you actually go over by where this other guy's just sitting there standing, don't you?
Yeah, I think I would describe it as splitting the distance as well as continuing to look at Mr. Perez.
Okay. So you've got to both keep your eye on Mr. Perez, correct?
Yes.
Make sure no witnesses talk to him.
Yes.
As a matter of fact, when you're talking to Mr. Perez, you told this other guy, like, you got to back off. I can't have you contaminating witnesses, right?
Hi, Susan. Yeah,
So
I'm the attorney. This
making
is
sure
my,
no one crosses the line.
I'm an attorney. This is
Keeping
my
your eye on
stream. I'm
Mr. Perez.
commenting on it.
Going speaking to Mr. Irrelevant, right?
Correct.
Does the third guy at any point ever do anything other than just stare at what's going on at the crime scene?
No.
Does he ever look at you?
No.
Does he ever say he's got any information?
No.
So if anybody's describing him as a witness, they're just guessing.
Correct.
Okay. Now, additionally, since we have you up here, in addition to being a patrol officer, do you have another job?
Yes. Kind of unofficially, I would describe myself. I'm the head bicycle mechanic for the Milwaukee Police Department.
And when you are the
Bicycle mechanic.
head bicycle mechanic, did you have any other specialized training in civilian before becoming an officer?
Yes.
What was that?
I worked for 4 years at a charitable organization in Chicago called Working Bikes. That was a charity focused on bicycles. And through the department, I also went to a training course at the United Bicycle Institute, which is one of two, I believe, bicycle trade schools in the United States for a certification course.
And do you work on bicycles for the Milwaukee Bicycle Unit?
Yes.
All right. I'm going to show you what's been marked as State's Exhibit number 86. You were asked to take a look at stills of the suspect in this case. Is that correct?
Yes.
And specifically, were you asked to take to see if you could identify the possible bicycle that this suspect was on?
Yes.
And what was, as you're looking at it, what did you believe that this bicycle was when you were looking at the photo?
It's called a GMC Denali.
Okay. And what made you think that this was a GMC Denali?
Very specifically, the combination of a grip shifter, which is a gear shifter that you have to twist. That's typically only
Defense
put
should
on
object to this. I don't see how this is
mountain bike or
relevant.
something that's configured as
We
a
know it's
mountain bike.
Theodore. We know he did
It
it. We know
slides
he
on
was
the end
there.
of a flat handlebar. The very unique thing about the GMC Denali is it has road-style handlebars, which are curved down. They're also called drop bars, or sometimes people refer to them as ram horns. The grip shifter, you can't slide it around the bends and the drops to get into position. So whoever manufactured the GMC Denali, I don't believe it's General Motors Company, I think it's licensed, made the bizarre choice of cutting the handlebar down the middle to slide the shifter on, and then putting a shim over it and clamping that in the stem clamp. And when I worked as a bicycle mechanic at Working Bikes, we would occasionally see this bike, and it stands out because frankly, it's bizarre, almost an absurd choice by whoever selected the components for that model. This picture very distinctly shows a grip shifter combined with the road-style handlebar. That's the only bicycle I've ever seen that on.
So when officers, before they do a search warrant, before they identify anybody, detectives come to you with this and you go, you should be looking for a guy with a, what kind of bike?
GMC Denali, so it's licensed like the SUV, you know, but I don't think it's actually General Motors company. But
And showing you what's been marked State's Exhibit number 60, that would be the type of bike that we see here, is that correct?
yes.
All right. Thank you, no further questions. Just a couple of questions for you.
Now, you testified just in your cross that, you know, the third individual didn't wave his hand at you, correct?
Correct.
He didn't say, hey, I got information for you, correct?
Correct.
But would you agree that it's your duty as a patrol officer to seek to get information in a homicide investigation?
If that is my assignment, or the assignment of that officer, yes.
Okay. So it's not a civilian's duty to go to a police officer to say, hey, I have information for a homicide, correct?
I suppose no.
No further questions. I would like to move Defense Exhibit 15 into evidence.
Other than the prior objections, any objection, Mr. Hubner?
Yeah, I'm going to object to 15 because 15, I think, contains way more than what was played. If you're only moving the portions that were played.
What we moved and received is exactly what was played, nothing else.
Okay, thank you.
Mr. Hubner, anything else?
No, thanks.
All right, you can step down, officer.
As much as I would
All right,
like
ladies
to
and
call
gentlemen,
in
it's a couple
sick
minutes after
for
12. We're going
tomorrow.
to break there for lunch. By now, you certainly know the drill. Don't discuss this case. Don't deliberate. Don't do any research on this case. If you run into the lawyers, parties, witnesses, anyone involved in this case over the lunch hour, they've been instructed not to speak to you, and you should not speak to them. I'm going to ask you to be back at 1:15. We'll try to start between 1:15 and 1:30. You can follow my bailiff out. Thank you. Everybody else can remain seated and silent, please.
Oh, I think the judge is going to talk to somebody very tersely.
All right, the jury's out. It's 12:05. If I did not make this record earlier, the defendant's in court. He's in custody. He's in street clothes, as he has been for the entire trial. After lunch, who's the defense next witness?
I'm sorry, Judge, what was the question?
Who's your next witness?
I believe it's going to be Lorenzo Hernandez, officer.
Say that again. Who?
Officer Lorenzo Hernandez.
And then who else are you planning this afternoon?
Stephanie Trotter.
And who else?
Dr. John Black. And that there might be an issue
Kyle
I
Rittenhouse
think the
is
state wanted to raise.
expert.
Yeah, I do have an issue on that. So when, Your Honor, when we were noticed, I'm sorry, we still on the record?
Yes, for a few minutes.
When we were noticed as to Dr. John Black, we were told he was going to be testifying to exposition only, simply just general. Yeah, sorry. Exposition
Set up
only.
the court reporter.
That there wouldn't be anything specific to this case, that all he was going to do is just generally speaking, it's in both of their notices. On Saturday.
Speak about what?
Well, he was going to, well, I don't really know. That's what I was trying to get. My understanding was he's generally going to speak about how video sometimes captures more detail than what people see, general feelings on how...
General information about videos.
And heightened emotions and how that can cause tunnel vision and how sometimes we get 20/20, whatever. It was all going to be general. It was not going to be specific. Defense counsel specifically highlighted me to 2 paragraphs and some other testimony he made in an unrelated case and said that's where they were going for me. Okay, fine. I asked, I was like, are you going to be attempting to get him to testify about the defendant's actions? I was told no. On Saturday, for the very first time.
Saturday meaning 2 days ago?
2 days ago. On I get 2 video
Elizabeth,
clips
I'm
that
tickled
apparently
300
Mr.
people are
Black has
watching.
made, in which he's going to be attempting to testify as to the defendant's actions.
That's not accurate, Judge.
Well, hang on. First, Mr. Huebner gets to finish. But, counsel, we don't do trial by surprise in Wisconsin. Why would we be turning anything over to Mr. Huebner on a Saturday, 5 days into a trial, knowing that I have told the jury and I expect both sides to complete this case by tomorrow is a problem to begin with. Mr. Huebner, go ahead.
Well, that's basically it. I don't know how it's changing. All I know is I was noticed as to general, and defense counsel kept telling me it's going to be exposition. He's just going to talk generally about people.
By the way, we've discussed this multiple times
Correct.
at pretrial motions. I've made rulings, which
Yes.
are not going to be revisited for any reason that I can tell so far.
So that's just my main issue. Maybe we can bring this up after lunch and defense counsel can...
Mr. Ahmad, briefly, in 30 seconds.
So, Judge,
Ah.
we already had our forensic expert for the video, Mark Robinson. He introduced video. When I met with Mr. Black, and we had spoken to him months ago, he had mentioned that he had video. We told him we had a different expert for it. And when I met with him in person for the first time over the weekend, because he's from out of state, he just showed me what he internally used to look at this case, and he created very short clips.
So
in
hang
slow
on.
motion.
You want to introduce evidence that you didn't have till Saturday, that you didn't give to the state, that the courts had no notice of, that was not listed as part of the motion, that was not listed at any point in time as to what this witness is going to testify about. Brand new video out of nowhere.
I sent Attorney Huebner the email that I got with the download links. It's just something he showed me to illustrate some concepts about video. I
But
understand.
Mr.
the
Ahmad,
state's-
okay, we're gonna break for lunch. That's too vague. It's something he showed me to illustrate concepts about video. What does that mean relative to a trial?
So, Judge, in this case, there's going to be 2 major issues that the exposition testimony will focus on. One being hindsight bias, which is like, now we know what occurred. So when we look at a video, we know what we can speculate. He could have done this. He should have done this, whatever. And the other issue is about video focus and how that differs from first-person perspectives, and what the eye can focus on in a moment is different from what video shows. And these are things that he testified to previously in a case that the court knows well about. So,
Oh, come on.
Mr. Ahmad,
Come
don't
on,
make
bro.
me say again that this is not the Rittenhouse case.
Oh.
Okay? It's not.
Once again,
And I don't
sports
care
fans.
what he testified about in that case. I do not care. He will testify under the law and the facts in this case. And you and your co-counsel had multiple motions, a dozen at least, that were filed, all of which were ruled on. Mr. Huebner, you can have
This
the
is
last
turning
word for
into a
now, then we're
snuff
taking a
film.
break for lunch.
Your Honor, I don't know why the defense counsel is going to, which is what I was told he was going to be doing, is generally speaking as this whatever hindsight 2020 whatever, and how video captures more than what people say. I don't know
It was
why
a
he needs
bullshit.
video clips, because the only attempt then in the video clip is for him to somehow render some expert opinion as to what the defendant knew or saw or could have seen. All of that is not relevant. He cannot testify as to what other people said. So he doesn't need the video to do it. He can sit there and talk about, hey, video may capture more and what witnesses see and all of that. Fine. Don't care. Let's talk about it. But trying to somehow use video clips that I've never seen, that he's made, that I finally see for the first time on Saturday, I don't know what he's done to them. They're not the ones that were turned over to us by their other forensic expert. I'm objecting to the use of those clips.
All right, I'm taking under advisement. We're done. Back at 1:30 promptly. We're off the record.
Okay, I guess I'll start with what just happened. Defense tried to present, it sounds like, exhibits over the weekend they had not given to the state. It sounds like they had them and they should have known about them. It also goes against the testimony John Black was going to offer, which apparently was a little more general, but now they want to fine-tune it, which is outside of what they told. So now it's evidence that the state never had a chance to do. So you can't just merely surprise people with things. In an adversarial system, if you are the defendant, you have evidence you want to introduce, You have to give the prosecutor copies of everything you're going to show, just like the prosecutor gives you copies of everything he's going to bring in. So that was their problem. That's why the judge jumped on them. I know some people are asking about the self-defense here. Yes, whatever Jason Clearman said in the car probably caused Theodore to punch him in the face. I don't think anybody's going to disagree. If he dropped an N-bomb, getting clocked in the face was probably a fair response. Once Theodore left, though, the fight's over. That fight specifically is done. There's no more self-defense. Jason doesn't have the right to fight him at that point. The guy runs away. And then when Jason confronted him again, self-defense, now you have to reassess. Does anybody have the right to self-defense? Right then and there, that second, I think Theodore did partially. Because at this point we know the car was very aggressive in cutting over, forced him up on the sidewalk. Now, yes, there were stairs, but for all intents and purposes, he was cornered. If you think somebody's about to kick your ass and or possibly kill you, you're not going to turn your back and walk down some stairs. It's a great way to get shoved down the stairs. It's a great way to get killed. It's a great way to get hurt. If you start backing down the stairs and they attack you, you're not going to be able to defend yourself. So you don't have to flee once the fight starts or you think it's starting. So in a way, he was cornered. There wasn't anywhere for him to go. He might be able to try to ride his bike, but that car's going to catch him again. It's dark out. This is a guy who appears to be drunk, who outweighs Theodore by 60 pounds, and from what Theodore claims was being very belligerent, screaming, using racial slurs again. Now, the witnesses have said there was no screaming or anything like that, but, from Theodore's position, there are some grounds he could try to work a self-defense claim. Is it the strongest one in the world? No. Is it better than a lot of people? Yes. But this is by far the worst one out there. Is this going to be an easy acquittal for him? No. I think it's tough. Now, what do we know? Well, it sounds like the wife grabbed the wallet. Yeah, okay. Everybody's weird. Everybody has different things. Does that show a possibility she ran around and screwed with the crime scene and hid the weapon? It's certainly possible. Because at this point, the only witnesses who could have seen this knife were guys 200-300 feet away. They're not going to see the knife. So really it comes down to Evangelina Clearman and Theodore Edgecomb. Who do you believe? And hopefully Theodore does very good on the stand, because if he doesn't, he's toast. Now, I'm trying to read through some of these comments. Somebody said, well, why wasn't the wife charged for anything? There's got to be some foreseeability and some intent in your actions. So far, all she said was he wanted to talk to Theodore. Even then, I mean, what, conspiracy to assault or, charge him with felony murder? No, it's not her fault. Ultimately, this is Theodore and Jason. It's not her fault. I don't think she should be charged at all. Also, the screen went black because of nothing else to talk about, and the judge is done for lunch. So you guys get to see my appealing mug now. Let's see, what else you guys have questions about? Okay, so with the issues of the defense attorneys, here's the deal. When you're in court, you need to be very specific about what you say. When you talk about testimony, well, what testimony are you referring to? Oh, it's a statement from somebody on a video. Well, that's not testimony. Attorney Lamar, who's been up here a lot today for the defense, hasn't been very precise with his wording and his verbiage. You have to be, because words mean things at trial. It doesn't help that they've been kind of screwing around and playing fast and loose with the rules of court all the way in the lead up to this trial. That's going to piss the judge off. In addition, yes, they did claim he was being racist. So far, I haven't seen anything to claim that he has, and yeah, that's going to piss off a court, especially if they don't think they've done anything wrong. But at the end of the day, even if you got rid of that whole allegation made by the defense, these guys have been poor at this. I mean, I get if this is a DUI trial in a municipal court somewhere, fine. You can suck, you can trip and be slippery and not be 100% on it and maybe fudge and play fast and loose with the rules. But this is a murder trial. For criminal stuff, this is as serious as it gets. You need to be on your game. And the reason why the prosecution hasn't been getting hammered too much, they've been on top of it. They know what questions they're asking. They have their evidence ready. I mean, they've got it together. So it's not really, I don't think, racial at all. He's just not suffering these fools any longer and their stupidity. Elizabeth, you just mentioned you don't see the judge allowing an acquittal. He can't stop that. If the jury votes not guilty, that's it. He cannot throw out a not guilty verdict. He can throw out a guilty verdict if he doesn't believe there was evidence to convict, like such as people were worried about in Kyle Rittenhouse's case. But no, if the jury votes not guilty, that's it. It's done. The prosecution can't say, wait, we want another shot or you need to do something. Nope, it's done. All the judge can say is, oh, okay, well, you're not guilty. That's it. Now, I know some of you had mentioned, is it probably better if Jason had just driven on and just, went about his night? Yeah. Yep, he should have. I mean, if you're an adult and you try to get into fights, over dumb stuff, like getting in a fight over something you said to a guy on a bicycle. Yeah, you're a moron. If you're going to get into a fight, you better be willing to go to prison over it or possibly die for it. Arguing with a guy on a bike that, there's almost a fender bender, is that worth going to prison for? No. Is it worth getting in a fight over? No. But, he gambled. He played a stupid game and he won a stupid prize. That doesn't excuse Theodore from any culpability, but, one of the guys involved in this had a great chance just to walk away, and he didn't take it. Can you guys hear me? I hear people saying no sound. Okay. Yeah, guys, the court's on break until lunch, so we're not going to hear anything from them right now. Gabby Smith, the liquid diet. Yeah. Nothing wrong with the liquid lunch. Yes, funny lady. Right now, intentional homicide is the only charge on the table. Unless there's a motion for lesser included offenses, that's all they're going to consider. And I think at this point right now, it's murder is the proper charge. It's not manslaughter. Manslaughter is usually in the heat of a moment. And I, could see why manslaughter, maybe, but in this case, I mean, he intended to do it. There was no, I caught him sleeping with my wife or anything like that. He intended to shoot him, and he did. Violet, you're correct. It doesn't change whether or not he's guilty, but I do think it's important for people to consider as they go about their day. For example, if they happen to be in a car and somebody punches them, should I go follow that guy? Is it a good idea? The risk of getting into a fist fight with somebody you don't know in the middle of the night, what are the pros, what are the cons? What do I stand to gain? Well, mutual combat's only recognized in a handful of places anymore. I know, for example, in Ohio, if you want to start fighting somebody, you're still guilty. Now, it may give you some leverage in a negotiation with a prosecutor, but there is no affirmative defense in a lot of places to say, well, we both agreed to do it. And honestly, in this case, Theodore had retreated. Now, you might sit there and say, well, that's a bitch move to hop on your bike and run away, but he still gave up and left. So it wasn't mutual combat anymore. It was Jason Clearman being the aggressor and starting a new fight. Cheryl, I don't know if that it matters he was shot in the face. I know the prosecutor's going to make a big deal about it, but if you're right in front of somebody, I mean, a pistol is a pistol. I mean, it's not the hardest thing to take like this out and point it in the guy's face when he's like 2 feet away. There's not a whole lot to it. So I kind of understand why he shot the guy in the face, but it sounds like he's so close that was pretty much a no-brainer. No pun intended there. Oof. Elizabeth, he actually doesn't have a bad record. He had 2 misdemeanor charges for domestic violence prior to this, but I believe that's the extent of his record at this point. Let me check a little bit. Okay, I will correct. He did have a conviction for driving drunk and having a concealed weapon, but I mean, those aren't violent offenses necessarily. It's all misdemeanors on his record at this point. I mean, I think Edgecomb will probably, if he's acquitted, will realize that he shouldn't go run around with a gun like that and start punching people. So that could help. That could help him. I don't know if you heard me, Elizabeth, but yeah, if he's found not guilty, I mean, I don't necessarily think he's going to go out there and turn into John Dillinger. In fact, I think this whole thing has given him some life lessons that people may call you bad names, but you shouldn't go around punching them. And they might take offense to that and chase you. Oh, Playmaker, you were asking what I carried. That is a Glock 19 with a Hollow Sun red dot sight and a TLR1 light on it. Gabby, at this point, we don't know because really the only 2 people who would have been close enough to hear anything are Theodore and Jason's wife. Other witnesses were involved or a couple 100 feet away, so if Jason was screaming at the top of his lungs, yeah, we would have heard that. I don't know otherwise what we'll hear is said until Theodore takes a stand. Nancy, I don't know if you were here earlier when I mentioned it, but she was very evasive in answers to the prosecution. Like I said before, I think she was trying to do what she thought was helpful, but it just looked, made her look like a very distrustful person. Oh, very true. Cats, cats. Yes. You shouldn't punch people in the face, but you also shouldn't get drunk and use racial slurs at people. Um, like I said, both of those don't, punching someone in the face doesn't justify getting shot, and also using racial language doesn't justify getting shot or killed. Um, you know, it'd be nice in this world if people, cooler heads prevailed. But this night, it doesn't sound like that happened. Well, Persh, it wasn't just approaching. I think it's a little dishonest to call it just approaching. I also think it'd be dishonest to treat it as though Theodore thought the Klan was rolling up on him also. I think there's probably a bit of a middle ground there. Oh, I bet Jason's wife heard things. Like I said, I think she's trying to protect the image and do what she thinks is helpful to get Theodore convicted. Hey, LMB, I'm sorry. This is like my second time ever streaming. I had to figure out how to shut my mics down, so I apologize for all the key typing. I mean, Persh, I don't know if you were here. Persh, I don't know if you were here earlier when I said this, but um, think about self-defense kind of like if you're at the putt-putt course and the windmill's going around. When the windmill blocks your path, you don't have self-defense. And then when the windmill's in between the blades, you can shoot your ball, it's open. Self-defense comes and goes. Sometimes you have the right, sometimes you don't. If the person who's attacked you has already left, that's it. If they've retreated, self-defense is done. So as soon as, the right, that window for Jason to respond was like a second or two maybe. And then Theodore left and it was gone. And if Theodore never stopped, it'd be gone forever. Yes, that opening right when he was being punched, yes, he could have fought back. Now, he would have had to use proportional force. What can you respond with to a punch? Could he have thrown his car door open and knocked him off knocked him off his feet? Sure. Could he have shot him right then and there? Well, just like Theodore, Jason would have to show he was in fear of his life or serious bodily harm to himself or in fear of the safety of his wife regarding her life or serious bodily harm. If he can't prove that or establish that, he would not have the right to pull out a gun or a knife and shoot or stab him. He would be limited to non-lethal force. Well, Nancy, how much alcohol the wife consumed? Yeah, she was drunk driving, so she shouldn't have been there. I don't know. It doesn't change the fact that they may have been driving illegally, but still, they showed up and then Theodore ended up shooting Jason. So the drunk driving wouldn't give Theodore an excuse or an affirmative defense. I mean, probably should they have not been on the road? Yeah, but you don't get to claim that as an argument for, well, you know what? I didn't have the right to shoot him, but he shouldn't have been there in the first place. Yeah, it doesn't work that way. I understand where you're going with it, but that argument would fail. Let's see what else is going on. Oh, of course Jason had more than 3 beers. His BAC was 0.12. It takes a lot more than that. And just like her, when she said, oh, I only had a glass of wine. I've had a million DUI cases. I have also prosecuted a couple when I worked as a prosecutor for a couple of years. Oh, I only had a beer. Yeah, she had a couple too. Now, was she over the legal limit? I don't know. Wow, we are a million comments. You guys are really going at it. Let me see. Stacy, you mentioned something about long crime saying this isn't a lot. Long crime can kiss my ass. I don't give a fuck what they have to say. This is a public court proceeding. This isn't their stream. I don't care what that judge said. I'm not under his authority or jurisdiction. No, I'm going to stream it, and anybody who's got a problem, they can fuck themselves. I'm not worried about the judge, law and crime, or anybody. Now, yes, the idea that she took more than just the wallet, she was manipulating evidence. Yes, that opening right when he was being punched. Yes, he could have fought back. Now, he would have had to use proportional force. What can you respond with? Had to use proportional force. What can you have had to use proportional force? Yeah, sorry, that was had a playback issue. Crap, I lost my train of thought there. Grabbing the wallet. Yes, the defense's argument is he had the knife out or was planning on using the knife, and she helped sanitize the crime scene. I will tell you, that has happened before. I have had cases where my client's been in a fight or their weapons have been involved, and people have... It does happen. People hide guns, people hide weapons, people hide drugs. So... that's not out of the realm of possibility, but you have to show it's going to happen. You have to show that it happened. And right now, her grabbing the wallet, this lady just seems like a spaz. So, there's not a whole lot there yet. Yes, that look when you hear your own voice. Yeah, Jackie, law and crime's trying to go after him like that. Yeah, they're just upset he's got a better stream than they do, and he makes. They spent money on this, advertising, studio time, and he's some guy sitting up in Minnesota at his house, just owning them and making money on top of it. So yeah, I understand they'd be pissed off, but no, there's nothing they can do. Violet, you're right. They could have checked the knife for prints, but here's... I think actually the knife was checked for prints. When it comes to fingerprints, you need a special situation for them to come up. That's why, like, if people break into your house or break in your car, they don't always dust for prints because they can't find them. Just like with DNA. For example, this pop can. I may touch it. Are there fingerprints on it? Presumably so, but can they be retrieved? Not always. If the surface isn't right, if there isn't enough oil on my fingers, any number of things can affect whether or not a print exists. The same thing for DNA. Generally, when you touch things, you can leave DNA, but you don't always. I mean, I've had cases where a guy was in a shooting and he had a shotgun and he put in some work with that shotgun and you can tell he's using it. There's no DNA on, and he wasn't using gloves. Not a drop of his DNA was on that gun. And not a fingerprint was on that gun. And there's no video of him wiping it down. He drops it. It doesn't always happen that way. Yes, I agree. Her not calling 911's a bit odd that she will then start calling other people, but all I can say is people in traumatic situations do really weird things, and absent, there's other things she did are fishier, like getting the wallet. That's fishy to me. Not calling 911, yeah, that one's not as big a deal to me. You guys are posting so much on live chat, I have to scroll back to see what's going on. You guys are posting so much on live chat, I have to scroll back to see. Okay, Persh, I was trying to catch up because I didn't see you respond. Force has to be proportional, and if you believe that you are in fear of death or serious bodily harm, you have the right to use deadly force. Does Theodore have a clear-cut case of self-defense allowing deadly force? No. But like I said, he's got some things he can argue. That he was cornered by people using a car, and a car is a deadly weapon. And as soon as he got out of that car was a big guy who was drunk and being super aggressive. Those are all things you'd want if you were trying to justify deadly force. What's the one thing you're missing? The action, the imminency. Does he have a weapon? It's like that last little bit of it that he's missing, but a lot of that gets you to the idea of you saying, wow, he would probably be justified. Edgecomb got caught 6 months later, it sounds like, because he wasn't paying attention and messed up driving in traffic. Well, Brenda, the shooting was intentional. I think he meant to use the gun. I think he feels he had no other option. So, I mean, it's clear he intended to shoot. And I don't think the defense is going to argue that it was an accident. He clearly meant to shoot. He's going to claim he clearly thought he was facing a deadly force threat.